see a lot of students online. I think some of them are my students whom I've taught in the last few months. Good to see you all here. Good evening to you all. Hope everything is going on fine. And CMA is something that, though not directly, I have been indirectly a part of this organization or associated with this organization, or have had the opportunity to know a lot of people in the Coimbatore Management Association over the last several years, because my father was part of CMA and he was the president of this organization very long ago, the late Mr. P.N. Gopal, who was a very active member of the Coimbatore Management Association. So very, very happy and delighted to be here this evening. And I should thank my good friend, Professor Sadasivam, the director of the GRG School of Management Studies, for calling me and inviting me to this talk. And my special thanks to the office bearers and members of the Coimbatore Management Association for inviting me to give this talk. So let me move on to tell you something about property, a property that, unlike the money we have, the land and buildings we have, the jewels we have, this property is intangible. The other properties we can feel, we can use, but intellectual property is something that arises out of the presence of the mind. So I think I'm just going to keep requesting for the slides to move. So we'll move on with the first slide. And I don't think I'll be, I'm not going to read out the slide for you. It is there for you all to read. The human mind is capable of infinitely interesting things, as we would have seen over the centuries, from what man was 1,000,000 years ago, or whenever he started walking, he started inventing the wheel. All that is a product of the power of the mind. So that is what intellectual property is all about. And why do we need this kind of a right? Why do we need a right to protect something that our mind has created? It is the same reason as we need a right to protect our other properties. Now, if you have a land or a building, you have a document to show that it is yours, and to the exclusion of all other persons, the property is absolutely yours. Likewise, IPR laws, as they were created and as they have evolved over a period of time, are those that give you the right to own your creation, the creation of your mind, to the exclusion of all others. Of course, unlike the other properties that you have, IPR comes with a certain time limit and with a reason. Why do we have a time limit for IPR laws? We will see as we go. Next one, please. I have used the word ubiquitous on this slide, which means it is present everywhere. Now we wake up in the morning, and from the time we step into the bathroom to brush our teeth, to the time we go back to bed in the night, we are all part of intellectual property. We keep dealing with intellectual property throughout our day, from the toothbrush we use, the toothpaste we use, the shaving cream, the toiletries that we use, the vehicles that we use, everything, your mobile phone, your laptop, all those have got IPR. I think somebody has to mute their audio.
Done, sir.
Yes, sir. Done, sir. Done, sir.
All right, thank you. So,
Vidya, can you please mute everybody, ma'am?
we will go to the previous slide.
Vidya,
Yes, na?
can you please mute everybody?
Will do, na. Will do.
All right, thank you. So we will remain with the previous slide for a minute. Yes, thank you. So, and the world over, the manner in which intellectual property has evolved and grown and continues to grow is absolutely amazing, because of newer interpretations of the intellectual property rights that the courts across the world have been giving. We must remember that, like the other laws, like the criminal laws and the other civil laws, intellectual property law also is not common across the world. every country has its own interpretation, while Western countries like America and Europe, they may have a different interpretation. And countries like India, we may have a different way of dealing with IPR rights. However, the bottom line is, it is a law, or it is a set of laws that are put in place to give a right to a person who has either created something or invented something, so that people are motivated to go around and invest in their own intellectual resources to create facilities or products or processes which will result in, something like medicine in pharmaceutical companies, or good cars in the automobile sector. And they are assured that their invention is going to be protected, and they will be able to commercially exploit their invention. That is the whole intention of IPR law, so that we can commercially exploit, which in turn leads to socio-economic progress. When I say socio-economic progress, if there is a person who is going to start an industry to manufacture pumps, and if he has a patent for his pumps, he is going to put up a unit where hundreds of people are going to gain employment, and the people in and around that area are going to be benefited, thereby leading to socio-economic growth. And that is one of the main reasons why IPR has to be protected. Next slide, please. And as I said, these are statutory rights which are legally enforceable, meaning there are several laws that deal with IPR, protecting IPR rights. There is the Trademark Act, which deals exclusively with trademarks, the Copyright Act dealing exclusively with copyright matters, and you have a Designs Act for only the designs. All the rights under the Trademark Act, or a person wanting to protect his trademark, are clearly defined. If there is a violation, how should he go about protecting his mark or taking action against the person committing that violation, or the infringer, as he's called, are all very clearly mentioned in the Act. And it would be encouraging to know that courts now are more liberal in awarding damages, are more appreciative of IPR rights, and they go that extra mile to protect a person's IPR rights if he really has such a right. We will see, I have a separate presentation on what kind of action can be taken and what are the remedies available under the IPR laws. And having said that, obviously they are territorial in nature, because the law of this land, this country, cannot be applied to another country. So they define the rights within the geographical territory of India. Next slide, please. So on screen, you see the different types of intellectual property rights that are available. Generally, these are the types of intellectual property rights that are available across the world, and particularly in India. These names, some of them may be familiar to you, some of them may not be familiar to you. And the audience today is a mix of young students, professionals, and seasoned veterans. So the level of information, I have tried to keep it neutral so that everybody is able to appreciate the information that is being shared. Of course, people who have been dealing with all these things will know a lot more than somebody who's just hearing about IPR, or somebody who has a middle-level experience in IPR. So I have tried to keep it the presentation neutral, and hope the information is agreeable to all of you. We will now briefly see what each type of IPR right is, and how this right accrues on a person or an organization, and how he will protect that right, or how he will implement that right. Next slide, please. A patent is basically given for an invention, and it is a limited right. We will know, or we will appreciate as we go through the presentation, that for inventions, there are rights which are given. And then for designs, for logos, there is a different kind of right which is given. So for patent, for invention, the right that is given is called a patent, and it is dealt with under the Patents Act. What happens? What is a patent? And what can be patented? What cannot be patented? I'll briefly explain that. Any process, any invention can be patented. But there are certain requirements for the patent office to appreciate and to award the patent to the person who has made the application. Under the Patents Act, one very important thing is, unlike a trademark, which we will see, under the Patents Act, the very important thing is first to make the application will be in a position to enforce the right. So if there are two people who have invented the same thing, the first person who goes to the patent office has the right to the exclusion of everybody else. The person who has delayed in going to the patent office cannot get a patent for his product. What does the patent do? What does grant of patent effectively do? If I have a patent for a product, then nobody else in this country or nobody else, in this country, because patent, you can enforce it only in India. If you want a patent in another country, you have to apply separately. So if I have patents in multiple countries, wherever I have a patent for a product or a process, nobody else can do the same product or the same process without getting my permission. And my permission usually comes at a cost. As I said, it is to motivate people to invest in resources for inventions and for socio-economic progress. So it is a limited right granted. And who grants the patent? It is always the state. All intellectual property rights are granted by the state, meaning the government. Next slide, please. So what is required for a product or a process to be patented? There are 4 requirements, fundamental requirements. If the product or the process does not come under these 4 requirements, then it cannot be patented. Number 1, it has to be patentable. The subject matter has to be patentable. There are certain things which cannot be patented, which I have dealt with in the subsequent slides. So if it falls within that category, you cannot patent it. The first and the most important requirement for patenting is novelty. It has to be new. Whatever you want to get a patent for has to be new. Something like that should not have been existed in the past. Nobody else anybody else should not have made such a design or a process. So it has to be new. First requirement. Second requirement, non-obviousness. That product or that process, how it works, should be known only to me, the inventor. Another person of similar intelligence should not be able to find out what the product is or how it works or how the process goes without me explaining it to him. So it has to be non-obvious. There has to be an inventive step known only to the inventor. That is the person who has designed or who has created that product or the process. And it has to have the possibility of having an industrial application. What is the point in making something and getting a patent which cannot be used by anybody? So therefore, it has to have the possibility and the capability of large-scale industrial application. Next slide, please. Not only can you get a patent for a new product, you can also get a patent for an improvement to an existing invention. So I would talk about or cite the example of a young man who made an invention, an improvement to a drone, right? We all know that drones are there, but then he made a small improvement to the drone or the manner in which the drone would work and would work more effectively if they used that particular design. So the product is already there. He made an improvement to the existing invention. That existing invention, the improvement can also be patented. Next slide, please. So, as I said, you can't file a patent in one country and hope to get recognition all over the place. There is no international or global patent. You have to go and file in each country because the law in each country is different. The procedure in each country is different. The time taken to get a patent in each country is different. The validity of the patent in each country is different. So it has to be applied for in separate countries wherever you want your protection for this patent. Why do we need this? Because we may invent something, a product or a process, which we may not use in some other country. We may probably want it in the Middle East and Australia, and we may not want it in America. So we don't have to go and file a patent where we don't want it. That is one of the other reasons. Next slide, please. So what cannot be patented? When I told you that the first requirement for patenting is it should be a patentable matter. So these are the things that are exclusions to patentability that you cannot patent, naturally occurring substances or elements, medical processes, treatment of human. Now, if a doctor is doing a bypass surgery, a cardiothoracic surgeon is doing a bypass surgery, and he says that, I want to go and patent this process, he cannot do it because the objective of intellectual property law, apart from giving a right to the inventor or the creator, the law also keeps in mind the need of the society. It balances the need of the society with the right of the inventor, because we don't want somebody holding an exclusive right over a medical process. So that cannot be patented. Plants and animals. Next one, please. Biological processes and any invention which is used for contrary to public order or morality, which is against the law of the country effectively, that cannot be patented. Methods of business or playing games, all these cannot be patented. So you might not have seen somebody going and getting a patent for this is how I do business. These are the special steps that I have, and I want a patent. You can't get it. Next slide, please. So all these that was patent. We move on to the next type of IPR protection, which is trademarks. Now, I'm sure some of these marks. The one on the right corner, that is the red and blue ball that is there. Even if the name is not there, I'm sure everyone watching this presentation will say that is Pepsi, or the tri-pointed star that is in the middle. All of us know that is Benz. And that is why it is important to protect trademarks and logos, because we don't want somebody to exploit the hard work, the investment that this particular brand has put in over a period of time to make it such a famous mark, and to create an image of goodwill in the minds of the customers who, when they see this mark, attribute to a certain degree of quality and a certain degree of guarantee. Next slide, please. So these are the things that can be trademarked. You have names, symbols, headings, labels, anything. You have a design, a combination of a name and design. You can have a word mark and a trademark. The important point in this slide is the word used or proposed to be used. So it is not required that you go and get a trademark only for a product that it is already being manufactured, or it's already being used. Now, if you are, a lot of students are here, a lot of entrepreneurs are here. If you are in the process of manufacturing or bringing out something in the next couple of years, and you want to keep that name ready, you don't want to lose an opportunity, you can file an application and say, I propose to use this in the future. Of course, you have to keep renewing it. And you have to remember that if you register a mark and do not do anything with it for 5 years, then there is something called acquiescence that comes into play. It will be considered that you have abandoned your right to use that mark. So please bear that in mind. You can register a mark or anything that comes under the trademark for either an existing product meaning that you have been manufacturing a product and it has got a name, but you have not got a trademark for it, but you have been doing it for 15 years or 20 years. You have not got a mark. Somehow there are several cases that we come across, very popular names, which I don't want to mention on an open platform like this, which have been in existence for a long time, but we were quite surprised that they didn't go and get their trademark registered. Only when they subsequently got into some trouble by some newcomers, then they went, and now it is all a legal process is going on. So anybody having a product here, a good popular name, and you have not registered the mark, maybe now is a good time to go and do it. Obviously, the intention of trademark is to distinguish your goods from somebody else's. And that is why we have, the moment you see a tick, a swoosh, it is called, it is Nike. And so many other marks like that, which by virtue of their long presence in the market and by virtue of the popularity the products are enjoying amongst the customers, have become easily identifiable with that particular maker. Next slide, please. So registration is an evidence of ownership. And not only are you having ownership over that mark, you are also telling the rest of the world that be careful, do not use this mark. I own it. And you would have seen some of the marks having, you have the name and there is one small letter TM with a circle on top, which means the application is filed and it is pending approval. And once the approval is given, you will have that TM replaced by R with a circle around it, which means the mark has been granted and the person who is owning the mark can enjoy absolute ownership over that mark to the exclusion of others. And if somebody else is going to come and mess or infringe upon the right of the owner of the mark, he is open to take action as provided under law. Next slide, please. Now, this is a very interesting thing. It is a contra to the Patent Act. Now, the Patent Act, we saw that you have to go and file a different application in whichever country you want protection. The trademark, with the dynamic movement of marks, unlike patents. Patent is an invention or a process, but a trademark travels across geographic boundaries without limitation, because goods move from one place to another. So there was a treaty that was signed, which is called the Madrid Protocol. Earlier, there were about 90 countries that one could get the mark covered, and now it has gone up to 128 countries which have signed the Madrid Protocol. In effect, what happens? If you want your mark to be protected in one among these 128 countries, or in several of these 128 countries, or in all of these 128 countries, you can do so by filing an appropriate application and paying the necessary fee for as many countries in which you want the protection. So I can file an application in India, and I can say that I want, these are the countries or these are the geographical areas where I want protection for this mark, pay the appropriate fee, I have protection for that mark in those countries. So that is what this treaty is enabled. And unlike the patent, where you have to file a separate application, obviously you don't have to go and do this if you don't need it. If you are going to be doing business only in India, you are not required to go and file an application for getting protection in some other country. But many businesses these days are transcontinental, and hence this kind of a provision will be a blessing for all those businesses, because you don't have to run around to different countries to get protection there. Next slide, please. Now, there are trademarks which are registered. There are trademarks which are not registered. Simply by virtue of being used for a long period of time, even though the mark may not be registered, it has acquired distinctiveness, meaning that mark can stake a claim over another mark, even if the other mark is registered, and say that I am in the business for a longer period of time, so you cannot use my name. The other person cannot take a stand saying that, no, you are not registered, but I am registered. No, it doesn't give him that right. That is the flexibility that the Trademark Act has, or the trademark law has, because what is the point in me doing business for 50 years or 60 years or 100 years, developing my mark, developing my brand, and somebody comes in, last week and registers a mark. Because I have not registered, I should not be punished. But obviously, the wise thing to do will be to always register your mark. But in the event of a mark not being registered, if it has acquired distinctiveness because of prolonged usage, then it has a certain degree of right. Yes, please. Next one.
The holidays not close.
So basically, I have said that there are marks which can be registered, and there are marks which cannot be registered also. So if there is a mark, now if you see the trademark registration process, there are different classes. Class 1, class 2, class 3, class 4, so on it goes to different classes. Each class deals with a particular type of good or services. So if you have sports, related to sports goods, sports training, sports garments, so on and so forth. It may be class 40. The previous slide, please. If you have other services, each class covers a different type of service. So if I have registered my product in a particular class, and if somebody else has a similar mark or deceptively similar mark, then they cannot do it because I have already registered. But then, if I have registered, for example, under class 25, which is a certain types of goods or services, and that mark wants a registration in class 45, which has got nothing to do with the goods I am doing, which has got nothing to do with the services I am rendering, then it may be registered unless it is not a well-known mark. A well-known mark is protected under the Act itself, even if it is not registered under any class. Say, there is a case, a landmark case that was decided by the Supreme Court, which is the Daimler-Benz versus Haibo Hindustan case. As we all know, Benz is a product. The moment you see the tri-pointed star, we associate that with a world-class automobile. But then there was a company called Haibo Hindustan that started making Benz undergarments, totally unrelated, and they had a similar logo to Benz, a man standing with his hands folded up like the tri-pointed star, and they were making men's undergarments. And this is a stand they took in court, saying that no, Benz is registered in a different class. We are not registered there, but we have registered ourselves in the garment class. So Benz can't effectively stop us from doing this business. After multiple rounds of litigation, we'll not go into that now. The Supreme Court finally held that it doesn't matter, even if they are not registered, they are a world-class automobile company, and any customer or any person who hears the name Benz will only associate it with a world-class automobile and not anything else. And Benz was allowed to get an injunction against the garment company. And later on, the Trademark Act itself was amended to provide for specific relief to well-known marks. Now, if you are a well-known mark, you can file an application itself under that section and say that I am a well-known mark. And if the trademark registry accepts your claim that you are a well-known mark, then the moment you get your trademark registration, you have protection in all classes to the exclusion of all others. Next one, please. Yes, you cannot register state emblems. Now, you can't go and try to get a trademark for the Ashoka Chakra or whatever. They are all government, used by the government. We cannot get it for private parties. Next one, please. All right, this is quite self-explanatory. We'll move on to why do we need a trademark? Because you want to distinguish one goods from there. That's what I meant by saying that. And then you have the trademark and a trade name. Now, Walmart, the company is called Walmart Inc. INC, Incorporated. Okay, they are incorporated in America. But they are known to be doing business as Walmart. So the trademark registration they can get for Walmart INC, and the trade name, they can get it for just Walmart. But the moment the customer sees the name Walmart, he is going to associate it with that company. So that is a difference between a trademark and a trade name. Next slide, please. Yeah, I have already explained to you about a well-known mark. You are citing the example of Daimler-Benz case. And there is something called a collective mark. Now, say if I'm going to start a business with my friends, 4 or 5 of my friends, and we don't want to form a partnership, and we want to do a business, say, let us take, for example, a restaurant business. I am situated in Mumbai, my friend is in Delhi, another friend is in Chennai, and another friend is in Bangalore, and we want to all start a same business with the same name, but we don't want to become partners in the business. So we say we want to name the restaurant ABC. We, make a logo, a design, and get collective ownership of that mark. So he can use it, whoever is in Chennai can use it there. I can use it in Mumbai, the other person can use it in Delhi. We are all collective owners of that mark. So that is a facility given for people who don't want to come together and start a partnership or a company just for the sake of getting a mark, but enabling them to get a right over a mark without being partners. Next one, please. And we have the other marks like certification marks. Now you go and buy gold. There is a particular mark for that. And the gold companies, the jeweler retail outlets, they have their advertisement saying that we have this, so we are the quality is better. And you have Agmark, ISI. When you see these, silk has a mark. When you see all these marks on a product, we have the belief that they have undergone a certain stringent level of monitoring, both during production and later. So these marks are generally given by the government. These are not available for individuals to give. Next one, please. We move on to the next type of IPR right, which are called geographical indications. GI is, when we say Kanchipuram, the immediate thing that comes to our mind at this time of the evening, probably idli will come to mind. That also probably, is something worthwhile of GI. But the other thing that comes to our mind is saris, Kanchipuram saris, Tirunelveli halwa, Darjeeling tea, so on and so forth. So these are given to products that are endemic to a certain region, that are very, very, a particular area is known for that product. And the GI tag, it's called a GI tag. A GI tag is given to that particular region for that particular product. We'll see how in the next few slides. Next one, please. So as I said, the moment we think of a particular area, we are reminded of a particular product from that area. And you will see that a lot of people in that area will be making that product. So say, for example, as I said, tea in Darjeeling or sari in Kanchipuram. Say somebody is coming from the United States of America or Australia who has never come to India. This is the first time they are coming to India. And they have heard that you get very good silk saris in Kanchipuram. And how do they know? How do they convince themselves that they are buying an authentic silk sari from Kanchipuram? These saris that they want to come and buy will have this GI tag, because that area has been granted the right to use this GI tag, again a right granted by the government. So likewise, I go from here to Switzerland. They have chocolates. So if I want to buy genuine chocolates, I can look for a GI tag. I can ask the shopkeeper, do you have a GI tag for this product? And if a GI tag has been granted, then that means I am buying an authentic product from that region. Next slide, please. Yes, of course, you have wine, spirits, cheese, so on and so forth, all of them having GI tags. If you have been reading newspapers, if you have been following the news, the need or the interest shown by various areas to get GI tags for their products is slowly increasing now. Now, 5 years before or 10 years before, this kind of interest was not there. Now, with the world expanding, the boundaries literally becoming seamless. Now, I don't have to go necessarily to Switzerland, or they don't have to come here to buy these products. They can do it over the internet. But when you're posting your product over the internet and saying that I have a GI tag for this, it means something else. It gives a certain different level of recognition for that product. So now there is an interest in getting GI tags across the world, particularly in India. Next one, please. Okay, that was GI. Other things about GI is it is given by the government. It is not given to an individual. A GI is given to a region. It is given to an agency in that region, and only the agency can use the GI tag. If anybody's right is violated, they can approach the agency, or the agency can initiate a litigation on their behalf, or the individual can also, provided he is a member of that agency. Then we come to designs. As the picture indicates, there are so many things that we use from morning to evening. All of them have a form that you can hold and use. if you take mobile phones, there are 100 different types of mobile phone designs. Likewise, in laptops, in televisions, the cars, the seats, the furniture, everything has a different design. So if I have a particular design which is popular, we all know that once a product becomes popular, there is an immediate rush for imitating that product. It is not only product, this imitation or the need to feel like the successful product is a basic urge in any human being. That's why we try to dress like our film stars, and it'll also be good if we do the same thing with our traffic rules and try to follow somebody who's following the traffic rules. But where it is not very comfortable, we don't do that. But where in most places we do tend to copy success, and that is one of the reasons why these designs are also protected. Next one, please. Whether it is a 3D application like a bottle or a 2D application like a bed sheet, you can get a protection for any of these designs. It doesn't matter. It is not required that only a 3D design can be protected. Next one, please. So what is the requirement? Like patent, it has to be new and original. You can't go and get a design protection for something that is already there. And again, like the patent, it should be capable of mass production or for application, because we don't want somebody getting a protection for something that cannot be used by anybody. Now, if you see the world of invention, if you see the history of inventions in the field of science, there have been several great inventors. All right. And they invented so many things which were not useful also, which were totally useless. In due course of time, they were discarded. Only the inventions that were useful for mankind at large, they were only given the right to be used, or given the right, or the intellectual property right was given only to those designs. Likewise, industrial designs have to have the capability of mass production and for being utilized on a mass scale. Next one, please. Now, this is the most recent, I wouldn't say recent, but the most dynamic in terms of, IPR protection. Now, I was, wondering how an integrated circuit, your phone has it, your watch has it, your computer has it, and your television has it. We get a new model almost every week. With this kind of dynamic movement, it is quite a challenge to get a design, integrated circuit or layout design protected. And it is really fascinating to see how the law deals with this particular aspect of granting IPR protection, as the development is so fast, and it is still at a nascent stage, I would say, in India as far as litigation is concerned, but it is happening. Next one, please. Yeah, this is anybody who's an electronic engineer here would know this. It is all your electronic products have something called a motherboard, and a motherboard is nothing but a layout of transistors and other circuit elements, wires connecting everything, which for a common man would make no sense at all. It is an integrated circuit, basically a semiconductor. But for the person who does this work, but for a person who does this design, if he sees one motherboard and puts it across to the next one, he will be immediately able to say the difference. And hence, if I have a pattern of layout of transistors, which I think is going to make a difference in the product that I am creating, then I need to have this protection so that somebody else doesn't take and copy my design and benefit from my hard work. Next one, please. The next type is a trade secret. We all know, we have all consumed this particular beverage in very large quantities across the world, but we have absolutely no idea of what is the combination of the chemicals or the formula that goes into making of this particular beverage. I always have wondered in Coimbatore, I have always wondered that how does Annapurna make that sambar with that taste? Now, there are so many other people who have tried, but they have not been successful. There is something that they do to that sambar that is very unique. As I said, we try to imitate success. There are other people who try to imitate that success. They wanted to make sambar like Annapurna, but I don't know, for some reason they are not able to make it because of something, some process or some ingredient or the way they treat ingredients, which is a well-kept secret. And why do we need to keep this a secret? Next slide, please. We can move on to the next slide. Yes. Once I give out the manner in which I am making this particular product, then I have lost my uniqueness. Everybody else is going to use it. Everybody else is going to exploit the unique formula or unique manner in which I make it. If I am not protected, if I am not allowed to guard that secret, and if everybody else is going to be permitted to use it, then I am put at a severe loss after having spent a lot of time and energy and resources in bringing out that product. So how do I guard this trade secret? Obviously, when I employ people, they are going to know my process. They are going to know what all I do to bring out that particular, taste. I am told that the Coca-Cola formula is known to 3 or 4 people only in this whole world. And nobody knows who they are. Nobody knows where they are. And in the event of all the 4 people not being available for some reason at the same time, then there is a separate process to access the formula. That is the importance they are giving to the manner in which they make that beverage. That is the importance that they are giving to the trade secret. So now these 4 people know. And we have seen in human history that people can be purchased. Across history, we have seen that several times, and we keep seeing that on a daily basis now. People can be manipulated, people can be motivated to do things that they wouldn't normally do. So how do we do this? So you have to, first thing you have to do is to keep the number of people having access to the secret information to a bare minimum. There is something said in a lighter vein that if you want something to go around, tell people, please do not tell anybody. I am telling only you. Please keep it a secret. If you do that, that will spread like wildfire and reach more number of people than you can ever imagine. And with, if you have to tell them, definitely don't tell XYZ. The first people to know will be XYZ. I don't know. That's how things work. The standing example or the standing proof for that is social media. You want something to go very fast, you can just put it on WhatsApp, any nonsense. You can put it on WhatsApp and send it to your friend and tell them don't share. I think by the end of the day, you will get a forward yourself. Whatever you started in the morning will come back to you yourself. This somehow doesn't happen to good information. It seems to be happening only for unwanted and bad information. Anyway, that apart. So keep it to a minimum number of people. Sign confidentiality agreements, because I had a consultation last week where one of the employees of my clients, he left abruptly without informing my client, and he went and joined a competitor. And whatever my client was doing had a certain sense of uniqueness to it, which the market was not knowing. And because this gentleman left his employment and joined a competitor, the competitor came to know about the process. Unfortunately, my client had not signed a confidentiality agreement. If he had signed, then we could have gone to court and got some orders. Of course, litigation is a cumbersome process. I'm not saying no, but then there would have been a way to enforce that right, which now he doesn't have. So if you want to safeguard your secrets, put it down in a document. And when the person is employed, when you give him the offer letter, when he accepts the offer letter, make sure that all these things are there, confidentiality, non-compete, so on and so forth. Everything is there so that if the employee is going to go out and trouble you, you have some legal remedy to stop him from doing that. Next one, please. Yeah, this is again a very interesting aspect of IPR law. Again, a very dynamic, a concept, and again something that we come across, we deal with day in and day out. Next one, please. We'll see what a copyright is first. For literary, dramatic, musical, and artistic works, it's a right given to the author, to the owner, to say that you are the one who created it, and you have the right to deal with it in whatever way you think it is required. So is it necessary for me to register a copyright? It is not necessary. The author is the first owner, always. So if I write something, I am the author, I am the first owner. Likewise, if I compose a piece of music, yes, if I write a song, and if I stage something dramatic, a drama, whatever, artistic work, sculpture, photograph, whatever it is, I am the first owner. I don't have to go and register anywhere, because I may be, as a photographer, taking hundreds of photographs every day, and it is practically not possible for me to go and register everything. If I am a writer, I may be writing 10 blogs every day, or one blog, 5 blogs, whatever. I may be writing 2 books, 3 books. It's not necessary for me to go and register it, because I am the creator. I am the one who has the first unfettered, undisputed right as the creator. So in terms of literary, dramatic, musical, and artistic works. Next one, please. Now, this interesting question that is always asked. Now, what happens if you write a story? Is it not possible? There are millions of people in this world. Is it not possible that you have written this story sitting in Coimbatore? What if somebody sitting in Orissa has the same line of thought? What happens then? Who has the right? We have seen, as a matter of research, that there could be a same line of thought, but there is always, almost never a same line of expression. The seed could be the same. The thought, the idea could be the same, but I wouldn't write it the same way, same manner in which somebody else would write. So you have multiple writers who write on the same subject, but then the expression keeps varying. And that is where the concept of substantial comes into play. What is deemed as copy? If I write something, and if somebody else has to stake a claim saying that I am the one who created this, I have a copyright over this. So how does a court decide whether A has the right or B has the right? And the test of substantiality is applied, and it is a matter of quality rather than quantity. In the sense, even during even in my other talks, I give the same example. Now you have songs which are popular for some reason. Now, the most recent example is the song that has won the Golden Globe Award, Not To, Not To, Not To. Now, somebody might, use write another song with an entirely different set of words. But if they are going to use Not To, Not To, Not To, it is a matter of quality rather than quantity. You can't say that my entire song is something else. I have only used Not To, Not To, Not To there. But it is that 3 words that make that song what it is. Likewise, Rowdy Baby. So many songs like that. If you remove Rowdy Baby from the song, then it is a different song altogether. So if you are going to write something else and put Rowdy Baby there, it is a matter of quality rather than quantity. So that will be the test of substantialness that will be applied in any matter that produces a copyright dispute. Next one, please. Okay, I think we are a little behind time, so I'm just going to go a little fast. Yeah, I have already said the author is the first owner. Move on, please. Yes, this also I have explained. Move on, please. If it is a producer, yes, photograph, it is the photographer. Yes, please. We can move on. These have I've already touched upon. Now, a copyright, I can also, if somebody wants to perform, This slide can be explained very easily with the example of Isainani Ilayaraja and SP Balasubramaniam episode. You would all followed it on multiple platforms. What happened there? Simple. I composed music for this song. You are going and singing, or your troupe is performing. You're making money. You're commercially exploiting something I created. So give me a royalty. So take license from me or take permission from me to do it. That's all they are saying. Next one, please. I can also assign my right. If I have written a book and I want somebody else to use the contents of my book, I can do it by giving them an assignment. Next one, please. It should be in writing, and the terms and conditions have to be mentioned. And we also saw that intellectual property right comes with a time frame. Beyond that, you can't use it. So what is the time frame? For a literary work, it is 60 years, and it is counted from the death of the author. So after 60 years after the death of the author, there is no more copyright for that work. It becomes free. Anybody can use it. Next one, please. And for a film, photograph, so on and so forth, it is 60 years from the date of publication, from when it was first published. Next one, please. I think that should bring us to the end of this slide. We'll go to the next slide, which is a very short one. I'm just going to quickly tell you that the remedies you have when the intellectual property rights are violated or interfered with. We saw the types of intellectual property rights we had. Now we'll quickly see what all remedies you have or one has when such a right is violated. So if it is ready, we will move on with the next presentation. It's a very short PowerPoint. Yeah, we can move on. Next one. I'll just tell you, yes. Why do we need to go to court, and why do we need to stop somebody from abusing our intellectual property? Because if you do not do it, then the value of your IP right, value of your product is going to be diluted. Coca-Cola is Coca-Cola only because they have protected it so very well. Likewise, Sony or whoever, all these big marks or whatever mark it may be. If you are going to allow 100 different people to use the same name, you are using your uniqueness. That is the main reason why you have to stop infringements. And you have to create multiple barriers so that the competitors do not enter. We will not go into emotions and ego and all that in this presentation. That was for a different presentation. We will. It is a costly affair, obviously. So, different types of remedy. Under the Trademark Act, you can get civil remedies and criminal remedies. Under the Copyright Act, you can get civil remedies and criminal remedies, which means a person can be sent to jail. And administrative remedies, which come before the tribunals or the registries themselves. When I have a trademark issue, I don't have to necessarily go to court first. I can go to the trademark registry in Chennai, likewise the patent office in Kolkata. Move on, please. Where do I file? Usually it is where the defendants are, because that's what the Civil Procedure Code says, or where the defendants are manufacturing and selling the most, or where the damages has happened. They may be manufacturing in one place, but I may be facing damage on a large scale in a different place. I can go there also, or where the IP is registered. Now, this basically goes to a concept called place of suing that comes under the Civil Procedure Code. But by and large, you are expected to sue where the defendant meaning the person who is infringing your right, against whom you want to make a claim. Next one, please. All right. So this talks about what happens in terms of copyright. If I am the plaintiff, I am going to say that there is a derivation from my work. The defense will be that, no, I did not know. No, mine is an independent work. No, I was using it as fair use. So there is no violation. Likewise, in trademark, the plaintiff, or if my right is being violated, I will say it is likely to cause confusion among the minds of the customers. It is diluting the offense of my mark. This is what I will say, that the person who's creating the nuisance will say, no, his claim is not valid. His mark is not valid. I'm in a different brand. And the trademark is being misused by him, not by me. He has abandoned the mark. As I said, 5 years, you don't use it. Where is the confusion? There is no lack of confusion at all. Concurrent use, meaning you are in a different class of goods. I'm in a different class of goods. So where is the right? So this is the different types of claims that can be made and the defense that can be taken under these marks. Likewise, in patents also, I may say that I am the one who's having the patent, right? The other person may say that it is not at all valid. I have not infringed. As I said, you have to have patentability means obviousness. It should be novel. It should be non-obvious. So he can say that it is not non-obvious. I know what he is doing. So I can demonstrate that it is not patentable. These are the defenses that can be taken. Likewise, in a matter of design also, they can talk about the look and feel, or the defense can say that this doesn't have large scale production capability. It is an invalid design. It has no functionality, or my design is different from his design. There is no similarity. These are the things, pros for and against, what kind of stance they are likely to take, and what kind of reliefs can the court give. Next slide, please. They can give an injunction, meaning if I go to the court and say that he is making something which is similar to my mark, the court can say temporarily, preliminary injunction, they can say stop doing it. Or in foreign countries, it's called a TRO, temporary restraining order. Those of you who watch Suits or other legal law series on Netflix or other platform might have heard this TRO quite often. And the other reliefs that you see on the screen, I will go to the specific types of reliefs which are there in the next few slides. Next one, please. Yeah. Now, what is the purpose of the court giving these reliefs? Somebody has exploited my hard work. Somebody has exploited my design, my IPR right, and made money out of it. So the court has to say that you infringed the legitimate right of a lawful user of a mark. Therefore, you compensate him. You have benefited by using his IPR, so you compensate him. So in order to give that compensation, what all will the court do? These are the different types of orders that the court can give. One is an ante-pillar order. What happens? We all have computers. We all use so many softwares in our computers. And we all know very well that many times that these are not licensed versions, right? And they are, companies like Microsoft, they know, but by and large, they don't go and enforce. But if there is a software which is very expensive, which is probably used for designing on a large scale, these days, companies that sell the software have methods of tracking it remotely. So remotely, they can find out if you have taken a software, purchased one version, and you're using it on multiple systems, which happens very commonly. So I have purchased one because it is the cost is so prohibitive. Each one will be 30-40 lakhs. If I have to use it on 5 systems or 6 systems, I have to spend a couple of crores to buy that. It is not going to be viable for my business to do that. Unfortunately, law doesn't agree with that line of thought. They can track remotely and find if the licensed version is being used on more than the permitted number of systems. They can go to court and say, please appoint a commissioner. And with that order, an advocate commissioner will come to the premises and seize the computers in the defendant's premises for being analyzed. How many software licenses have been used? What kind of usage has happened? Why? To decide the compensation, right? Because one has used the unlicensed version. So they are called ante-pillar orders. Then you have the Mariava injunctions, where I have, I have agreed to manufacture goods, garments for an international brand. And now I have some dispute with the person who has placed the order with me, but I have all his stocks with me. I have some 20,000 t-shirts with me, and I have some, unstitched garments with me. Now, the person who sent the garments to me is afraid that I am going to dispose or destroy these assets to realize my outstandings. So he can get an injunction saying that do not dispose that till you have the litigation is sorted out. And then you have the Nordic pharmaceutical orders, pharmacal orders, which where the court can direct a third party. Now, if I am withholding some information, I won't tell you. So I can go to court and say that unless and until I have that information, I cannot substantiate my claim. And he is withholding that information unnecessarily. So I can be directed to divulge that amount of information that is required by the plaintiff or the person whose right has been violated to file the suit. And then you have the dynamic injunctions where, there are multiple websites. I have the original website and there are people who are copying my website. So I go and get one injunction against one website. And if there are 40 others, 50 others also there, I don't have to repeatedly go back to court to get a fresh order. With the order that I have already obtained, as you see, the mirror, redirect, alphanumeric websites which are similar to mine, against all of them, I can use the same order without going to court by producing this order to the administrative side and getting a stay order extended to these people also. This is called a dynamic injunction. Next one, please. Yeah, this is a quaternion action. Again, an ex parte injunction is given against an anticipated wrong. Now, you might be seeing whenever a new film is released these days, the producers go to to the court and get an order that the internet platform should not stream these movies. Even before the release, they'll go. That is a typical example of a quaternion action. Okay, John Doe is. I don't know who is going to violate my right. If you, for example, if you find some unidentified person dead on the road, he is called a John Doe. And if it is a lady, it's called a Jane Doe. We don't know who it is. Likewise, I am not sure who is going to violate my right. So I can go and get an order saying that anybody who is going to do it in future, then that infringement may be protected. That is called a John Doe order. Next one, please. I think that should be the, okay, this is not very important. Next one. I think that should bring it to an end. Okay. So that brings me to the end of the presentation. You can probably close the PowerPoint. And if there are any questions, I'll be happy to take. And thank you so much for your patient listening. Any questions? I'm okay to take.
Good evening, sir.
Yes.
Excellent presentation, very informative. Puneet Krishnan here.
Thank you.
Just want to check, in how long does it normally take to get an injunction granted against typically?
So when we file a suit for injunction, usually what we file is we'll file a suit asking for an interim injunction.
Okay.
And if we are able to make out a case to the court, this is for a trademark, right? I'm assuming it's for a trademark. Yeah. So if you are able to convince the court that the offending mark is rampant and it is violating your mark, usually a preliminary interim injunction is given on the day you file the case or on the day when it is heard. Usually you file it and it comes up for hearing in 3-4 days time. So on the day on which the court hears your application, if it is convinced that an interim prima facie case is made out, an interim injunction is given the very same day on which it is heard. In case the court is not convinced to give an interim injunction, then it orders notice. The respondent comes, files his papers, and after going through everything, the court passes orders.
And then these have to be enforced through law enforcement agencies. How is it done? I mean,
you have a civil remedy, sir. You have a civil remedy also. You have a criminal remedy also. So if you want to go and file a case to restrain the respondent from stopping whatever he is doing, then you have to go to the civil court. Only a civil court can grant an injunction. The law enforcing agency cannot grant you an injunction. But you can go to the law enforcing agency for a criminal remedy. You can say that under the Copyright Act or under the Trademark Act, there are criminal provisions.
Yes.
And if you have made out a case, there the relief will not be immediate because it's a criminal action. The other party will be summoned, and only after thoroughly examining whatever has happened, the police will register an FIR and proceed with. So that is more for punishment for what wrong has been done. And a civil case is for preventing the wrong from being furthered. So there are two different aspects. You can simultaneously exploit both reliefs also.
Fine. Thank you so much.
Yeah, you're welcome, sir.
Participants, if you have any questions, you can put in chat or you can unmute and come forward. There are no questions in chat, sir.
Yeah, I have seen that. Yeah.
Okay.
Yeah.
Since there are no questions, shall we wrap it up, sir?
Yes, sir. I'm
Yeah.
fine. I'm fine with that. Yeah.
Yeah.
Thank you once
Before we
again,
wrap,
everybody, for your patience listening, and thanks to CMA for inviting me for this talk. Thank you. Thank you all.
Thank
so
you,
before
Kumar.
before
you.
we wrap it up, just a small summary of the session, sir. You have almost explained IPs and expanding with the advent of technology and globalization. It's a set of law in place to safeguard the person's creation. You discussed about the various types of IPR like patents, trademarks, geographical indications, industrial designs, trade secrets, copyrights, etc. And finally, you concluded the talk by why file an infringement case, because it's always to create a barrier to the competitors to enter. So it was a wonderful session, sir. Indeed, thoroughly we all enjoyed the session. I'm sure all the students have actually got a lot of insights. And more importantly, this session holds very important this week, because this week we are celebrating a Republic Day. So we should know our constitutional rights. So similarly, as businessman, entrepreneur, as well as management students, we all should know what is IPR. So definitely this session holds a lot of significance this particular week. On behalf of Coimbatore Management Association, I would like to thank Advocate Mr. C.G. Kumar for sparing his valuable time today with all of us. Thank you so much, sir. And I would also like to thank all our CMA MC members, our CMA office bearers for continuously supporting and motivating us to conduct this Monday Musings week on week. So thank you all once again, and meet you all in the next Monday Musing. Until then, it is bye from CMA.
Thank you, sir. Thank you all. Good night. Good night.
Thank you.
Sada, hi. Good night, Sada.
Hi. Good night.
Good night.